What is pretrial intervention under New Jersey law? Pretrial intervention, often referred to as PTI. If you, a family member or a friend, have been involved in a criminal case, this term and this acronym may come across your desk often. Here at the Bianchi Law Group, our team of former prosecutors are always dealing with pretrial intervention. We either have as prosecutors and now as criminal defense lawyers. Very important to understand what it is. Pretrial intervention essentially is what they call a diversionary program, which means it's something that the courts put together to say, listen, not every case has to go the full route of criminal prosecution. We can do something that meets first offenders typically in a place where they don't have a very serious crime. And if they are eligible for the criteria for the pretrial intervention program, I'll discuss that in a minute, then it basically is taken outside of the criminal justice process and kind of lays dormant from anywhere between 1 year to 3 years. There could be certain conditions, kind of like a probation, community service, making sure that you're drug and alcohol free, that you maintain a steady job, and certainly that you don't get re-involved in the criminal justice system. The benefit to the defendant by having pretrial intervention and being accepted into that program is if they successfully complete the program, the charges against them are ultimately dismissed. So in other words, what the court said is like, you know what, first-time offenders, minor offenses, typically, we don't want to stigmatize somebody with a criminal conviction that they have to live with for the rest of their lives. So if you are a valid person for that program, that's the benefit to the defendant. The benefit to the prosecution is they have an overwhelming amount of cases, and plus, prosecutors should hopefully recognize that not every case has to be handled with the full weight of the criminal justice process. So it alleviates their case burden, and it alleviates the court's case burden as well. PTI is an excellent program, but then the question becomes, how do you get into it? Now, there's a lot of nuts and bolts, and not everybody does get into it, but I'll say one thing that people have to understand very clearly, we're asked this question often, is that the PTI program, and whether you get in, is typically going to be major league driven by the prosecutor. They're given extraordinary discretion with regard to whether or not they're going to allow somebody into the program or not. And that's why it's imperative for the criminal defense lawyer, when applying for pretrial intervention, that they're very actively engaged in giving as much positive data to try to show to the probation officers who prepare the reports and the prosecutors who ultimately make the decision that your client is worthy for pretrial intervention. And there's a certain art form to doing that in order to leverage it so that your client gets the best opportunity possible at that decision-making process. Getting a denial, that is the prosecutor refusing to allow you into pretrial intervention, while it's possible to appeal, is very, very difficult because the law has made it very clear for multiple decades that it's what they call, the courts don't call it, but many of us call it the prosecutor's playground. In other words, they get to make the decision. Now look, as a former prosecutor, I get that. Sometimes prosecutors want to prioritize certain crimes over others. They want to do certain things for deterrence purposes, and they don't want to give somebody, quote unquote, a slap on the wrist. So pretrial intervention can be a great resolution for a defendant if you can get them into the program. Now, how does the program work? So you apply for pretrial intervention. There'll be somebody who's going to take a lot of data and information. It's going to be in the probation department initially, and they're going to make a recommendation to the prosecutor, and ultimately the prosecutor, as I said, makes that call. So for third and fourth degree offenders who are first offenders, it's a really good opportunity. First and second degree offenders can get into PTI. Of course, those are the more serious crimes, but it's less likely, the more serious the crime, the less likely it is you're going to get into pretrial intervention. And then lastly, and it's too long for this particular video, there's a number of criteria that the courts have interpreted as the valid factors. Both the courts have done that, as well as the court rule and the statute that says the various factors that prosecutors should take into consideration when making a pretrial intervention decision. And that's why it's very, very important to have a skilled criminal defense lawyer who knows pretrial intervention inside and out, so they can address those factors and not just have a person apply, but specifically be very proactive in addressing those factors. They're kind of like I always say, put it in a box with a bow on it to give it to the probation department and to the prosecutors, knowing what it is that the prosecutors are looking for. So that is pretrial intervention in a nutshell. nutshell. There's a similar corollary program. It's not called the same thing in municipal courts. We'll do that in another video. But if you or a friend should ever have a problem or have any questions about pretrial intervention and the value of having the case diverted out of the system in order to avoid the consequences of a criminal conviction, our team of former prosecutors at the Bianchi Law Group practicing throughout the state of New Jersey are more than happy to answer your questions. Thanks for listening to the video. It's a question we're asked all the time, so I hope this helps. Thanks.